All right, well, good afternoon, everybody. For those who don't know me, my name is Petra Mahy, and I'll be chairing this afternoon's session. And it's my pleasure to introduce our speaker, Associate Professor Supriya Routh, who has come a very long way to be with us here in Melbourne. He is the Canada Research Chair in Labour Law and Social Justice at the Allard School of Law, University of British Columbia in Vancouver. And his research interests include theory of labour and employment law, legitimacy of lawmaking for sustainable livelihoods, post-colonialism and informal workers in the global south, human rights and international labour law, and workers' collective action. So quite a broad spectrum of research interests. And he is the sole author of the book which he is going to speak to us about today, titled Labour Justice, a Constitutional Evaluation of Labour Law, and also an earlier volume on enhancing capabilities through labour law informal workers in India. He's also co-authored a textbook on Canadian labour law and also a volume on Amartya Sen and the law. So we might ask Supriya to present for around 25 minutes, half an hour, and then myself and Sean Cooney have also prepared some brief reflections, so we'll come on after that.
Thank you, Petra. And thanks everyone for showing up. Thanks to John, thanks to Sean for having me here and giving me the opportunity. And I would also like to acknowledge the Wurundjeri people's traditional territories on which I'm visiting today. And it's just fabulous to be here. As Petra mentioned, I'll talk about is it moving? No. My book today, which is called Labour Justice, a Constitutional Evaluation of Labour Law. So what I've tried to do in this book is I've taken the 2020 labour law reforms in India in order to make some broader points about labour law and generally conceptualization of labour law. So that's what the overall aim is. And in particular, the book evaluates the 2020 labor law reforms by employing a constitutional social justice lens. And I'll come to that in a moment, but during 2019, 2020, the BJP-led Hindu rightist government comprehensively changed labor law in the country. And I wanted to see to what extent those changes conform to the constitutional principles that are there. And as we'll see, Indian Constitution is quite big on labor rights and workers in the general constitutional framework. So just to clarify that in the book, I'm not talking about whether the labor law amendments or the repeal of the labor laws are ultra vires the Constitution. I'm not questioning whether it's beyond the scope of the Constitution. I'm trying to see whether it meets the social justice mandate of the Constitution of India. So, and one more thing I'll mention at the outset is I'm arguing that Indian labor laws are sui generis, and even though much of labor jurisprudence evolved with reference to common law contract, Indian labor law ought to be understood in a way that is different from the common law of contractual relationship. So the question that I seek to answer is, does labor law articulate a more fulsome picture of the constitutionally mandated reciprocal relationship between worker citizens on one hand and the state on the other? So this is a phrase that I've coined in the book, the idea of worker citizens, and I'm interested in identifying its role in Indian constitutional imagination. I do it for the reason of trying to understand how labor law furthers the idea of worker citizenship and how it sees the relationship between citizens and the state if we see citizens as worker citizens, which there is ground for us to see. So citizenship as a reciprocal obligation between the citizens and the state, that idea is nothing new. So in Western legal and political science literature, you'll see that there is a reciprocal relationship conceived between the citizens on one hand and the state on the other. But this relationship is conceived primarily with respect to civil and political rights. So citizens ought to participate in the political process of the state, and the state reciprocates by offering citizenship rights. So what hasn't had much discussion, and I think what's in some senses unique to the Indian Constitution, but not unique to constitutional understanding of different countries, is that this reciprocity is seen by means of work. So reciprocal relationships not only by means of political participation, but also by means of work. So Indian citizenship consists of, therefore, two parallel sets of obligations. One is legal rights that the state owes to its citizens, the duties of the state towards the citizens and the reciprocal rights that citizens would have, and then citizenship duties that citizens are obligated to perform. And the duty to work is a core citizenship duty, as I argue in the book. I'll move on to argue that worker citizenship is a core idea of constitutional understanding of Indian citizens. So you will never, you won't find the phrase worker citizen in the Constitution. It's my coinage, but I'm suggesting that if we read the Constitution, this idea is inherent in there. Article 51AJ, which is part of a chapter called Fundamental Duties, an Indian Constitution has a chapter on fundamental duties, citizens' duties that they ought to perform as part of their citizenship. Article 51AJ states, "It shall be the duty of every citizen of India to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to a high level of endeavor and achievement." My argument is, while civil and political rights are important, unless citizens are also conceived as worker citizens, the state is not rising to higher levels of endeavor and achievement. So in order to satisfy that component of the fundamental duty, we absolutely must understand Indian citizens as worker citizens before anything else. So in the fundamental duties chapter, there is no mention of civil and political duties of citizens, but duty as a worker in order to contribute so that the nation rises to a higher level of achievement is explicitly articulated. And I also wanted to point out that this idea is it's not I'm doing a fancy interpretation of constitutional law, it's also there politically. When we look at urban poor or informal workers, we'd see that informal workers, people who live in squatter settlements and slums and doing odd jobs here and there, they frame their citizenship rights in terms of their citizenship duties. So their claim from the state is based on their contribution that they're making towards the state. And this is a political claim that they're making, that they're suggesting that we are contributory citizens and we contribute to the city, we contribute to the state, and therefore it's the state's responsibility to, for example, offer us housing, offer us sanitation, or a range of traditional labor rights, and so on. So the idea of worker citizenship exists constitutionally. It also does exist politically. So that's what the argument I'm offering in here. And now, then I move on to this idea of worker citizenship being pivotal to the constitutional social justice agenda. Now, social justice in Indian Constitution unfolds by means of two primary parts of the Constitution. One is fundamental duties in Part 3 of the Constitution, and the second one is directive principles of state policy, which is Part 4. Basically, Part 3 is the Bill of Rights, right? And Part 4 is the state's duty towards the citizens. And here you'll find duties such as labor welfare, maternity benefit, and so on and so forth. These are not, Part 4 is not justiciable. It's not enforceable in a court of law. The guarantee is provided under Part 4. But Part 3 is justiciable. Although increasingly, Indian Supreme Court has read guarantees under Part 4 as part of Part 3. So you need education or you need health in order to have a good life. And right to life is a justiciable right. So that's how courts have often tried to make directive principles of state policy justiciable. So the Constitution attempts to achieve social justice through a careful balancing of individual liberty with social solidarity. So both of these, individual liberty and social solidarity, are parts of the social justice agenda of the Constitution. And these two are mediated by the participatory deliberative process. So the state sees very much this balance as being a balance that will be struck by its citizens by means of political participation. So the idea of worker citizen is central to how social justice agenda of the Constitution transpires. I've mentioned some articles from the Constitution. Fundamental rights, which are justiciable, Articles 16, 19(1)(c)(g), Article 23, Article 24. All of these directly refers to, in one way or other, workers or labor. And directive principles of state policy, Articles 38, 39, 41, 42, 43, 43A, 46, all of these directive principles of state policy also are specifically targeted towards workers. So thus, what I've suggested is the Indian Constitution's social justice agenda unfolds by reference to workers, and these are the worker citizens. So that's the line of argument that I'm pursuing in this one. So labor law reforms of 2019-2020, before the repeal of 2019-2020, which I've generally called the 2020 labor law reforms, before that India had hundreds, in fact thousands of labor laws, statutes, hundreds of statutes at the provincial level, at the federal level, the union, the state, the central government level, and then thousands of statutes by the different states. So what Parliament has done is in 2019-2020, they've repealed all of those existing laws into 4 different codes. So the code on industrial relations, code on social security, and so on. So each chapter of the book evaluates each one of these components. One looks at individual liberty and contracts, industrial relations. The other one looks at social security and social protection. And a chapter looks at worker participation in all of these, so deliberative democracy and so on. So some of the prominent features of these repeal include withdrawal of the state from labor relations, so from the contractual part of labor relations. It also articulated a social justice framework for informal workers, which existed for formal workers already, but they've extended it to informal workers. The still question remains how successful that is or how well it's done. And I argue that the reforms also undermine the scope of collective action, workers' collective action. So why social justice as an evaluative standard, and what do I take from that evaluative standard in order to understand labor law? This is just a context wherein the idea of justice, social justice in Indian Constitution is positioned somewhere between classical liberalism and social democracy. So there is scope for private law mediated relationship and public law mediated redistribution. The 3 components of social justice are freedom, equality, and solidarity. And it's also supplemented by participatory citizenship in furthering economic democracy. So freedom, equality, solidarity and all of these components are related by means of participatory democracy. Thus, there are three domains of social justice: the market, state, and civil society. And the Supreme Court of India says that the social justice structure, this framework, is an unalterable basic structure of the Constitution. So social justice is quite central in how social relationships, how fairness in social relationships unfold. And those of us who have read John Rawls, social justice is premised on the idea of social cooperation. And I'm arguing in here that work is the basis of social cooperation and the foundation of the constitutional social justice project. So work is the basis of social cooperation, and in order to have fairness in social cooperation, we resort to the idea of social justice under the Constitution. The other thing that I wanted to mention at the outset is that the idea of work or human agency, that's kind of a broader definition of work, not merely limited to work as an employment contract or employment relationship. I'm arguing that the idea of work or human agency is public in nature, in the sense that it furthers the ambition of the state at a broader analysis. So if social cooperation happens by means of work, then fairness in social cooperation ought to happen by means of labor relations. And that's the line of argument I've offered in the book. And since the idea of work is public in nature, I'm arguing that it's primarily the state's responsibility to take cognizance of workers' condition and then offer conditions in which workers could live the life that they value the most. So that's the state's part of the obligation. I have started with the argument that legislative enactments are better in pursuing social justice enumerated under the Constitution as opposed to judicial adjudication. So judicial adjudication is responsive, it's reactionary, as opposed to legislative enactments. And legislative enactments is where the politics and contextual analysis of different components of the social justice framework unfolds. And therefore, if we want to evaluate what happens actually with respect to the social justice framework, we should be looking at legislative enactments less than constitutional adjudication. And on that basis, I argue that labor laws are quite apt for such an evaluation. And labor laws operationalize two things. One is they try to meet the ideal of justice in actual context, and therefore offers two facets of accountability with respect to the constitutional social justice framework. And hence, the most appropriate basis, I argue, is to understand labor laws, the extent to which the laws collectively further the constitutional social justice project under the Constitution of India. So these are the three prominent things that I do in the book. So the scope and protection of market-based distribution, respecting basic individual liberties, the complementary redistribution of public goods through state action, upholding the principle of solidarity, and then finally the institutionalization and promotion of public participation in decisions about both operations of the market and the state in advancing social justice. So these are the three broad frameworks in which, by means of which I evaluate the labor law reforms. So, and the first component is market-based distribution, which is, of course, also conceived under the Constitution of India. Individual liberty, contractual freedom, and market participation are justiciable fundamental rights under the Constitution. So citizens could have these enforced. Work or employment, I argue, is broader than mere contractual exchange. And you'll see within parentheses, I wrote freedom of trade. Freedom of trade is the phrase that is used under the Constitution. And I'm arguing that freedom of trade is closer to the idea of work than employment contract. Contract, to my understanding, contract is a narrower version of freedom of trade, because work also includes various other interests and aspirations that are not captured by the contractual market exchange relationship. So I say the de facto contractual freedom signifies that the parties to a contract or market exchange should be at roughly equal position to exchange their respective promises. And I'm thinking that all of us have studied contract law. So the very basis of contract law is if you have something to exchange, you exchange by means of contract, and it assumes that parties are roughly equal. And when parties are not equal, there are a bunch of principles, unconscionability, duress, undue influence, and so on and so forth, in order to engage with situations where parties are not at equal bargaining position. So contractual freedom assumes, or employment contract assumes, that parties are at roughly equal bargaining position. Although I will nuance that in a minute, but for now, that's where the argument is. And I suggest that a mere emphasis on the freedom of contract or market exchange values only the exchange and the resulted outcome, which is efficient distribution, but not the scope of freedom underlying the exchange. So the suggestion here is that if we see labor relations merely by means of contract, we are actually not promoting an individual's autonomy or freedom of contract. We are seeing employment contract merely as an exchange, and the exchange is helpful under common law because the outcome is efficient, because private parties could exchange what they need between each other, therefore both of them are better off. So that offers a very contractual exchange-based relationship wherein the actual freedom of work or the freedom of trade is not taken into account. A contractual understanding of employment without also referring to other social commitments, including other individual freedoms, is restrictive of the very freedom that it purports to promote. And I make this point here because one of the core arguments of the government, the BJP government and Parliament, was that we are trying to promote freedom of contract. But my suggestion here is if we understand employment contract merely as a contract, we are actually curbing the freedom of trade or actual potential for people to work, because we are focusing in a very narrow exchange relationship, market-based relationship between individuals. Thus, my suggestion is that we need to offer intervention in order to make contract free in the sense wherein people are able to work, to do the work that they hope to do. So freedom of trade, that is. So inequality between employer and employee in both creation of the employment contract and day-to-day relationship required the intervention of legislation to set minimum standards for the contract. Because what labor law does is seeks to equalize the position of the employer and employee, and therefore it's in the traditional conceptualization of labor law or contractual understanding of labor law, that's the very reason of having labor laws, because it's trying to balance bargaining power between the parties. So Indian labor law has dealt with the disparity of market power between employer and employees by imposing reasonable limits on employers' freedom to run their business. So that's how traditionally Indian labor law unfolded. So it doesn't only talk about minimum wage and maximum working hours that constrains the contract. It also did impose direct limits on the employer's right to freedom. And this is part of the general structure of balancing bargaining power between the employer and the employee. So what happens to contractual exchange in the Industrial Relations Code? And this is the amended code, that's the repealed law now. I suggest that the IR Code, Industrial Relations Code, constrains workers' freedom of contract by failing to consolidate the background conditions for the de facto realization of such freedom. So what the argument here is, if workers were to participate in the market as equal participants in the exchange, they needed background conditions. And think of education, think of skills that workers might require. right? All of these are background conditions which enables the worker to participate in market exchanges as a roughly equal individual to that of the other party, the employer. When workers lack these skills or education or the background conditions that enable them to participate in the market effectively, they do not have the market exchange power, and therefore seeing them in exchange relationship as part of their freedom of contract is problematic. So, and I also suggest that mere indirect constraints, such as imposing minimum wage and health and safety laws, fails to create true freedom for workers as it fails to narrow employers' market freedom in any significant way. Labor law reforms also continue the government's non-intervention in the majority of informal working relationships. And here is the funny thing about the reforms. So the government argued that by means of the reforms, we are promoting market power of the workers. So we are creating more of a market exchange scenario, which is good for workers. Workers could bargain from themselves. Now, here we are talking about only about 10% of the workforce in the country. Indian workforce is equal in absolute numbers. Indian workforce is equal to the entirety of the population of Canada, United States, and Mexico, and then half of Western Europe. Among all of this workforce, it's only about 10% of workforce that are formal workforce and are entitled to some of these benefits. If market freedom were to be so good a component that the government or parliament intends to further, informal workers have always been part of the market without any kind of protection from the government. So why are the conditions for informal workers still so precarious, right? No one answers that question, of course, but that's something you could see in some of the government's argument. So the second component is state-based redistribution. And here we are thinking about social welfare and social protection and so on. So as I mentioned, formal workers have traditionally been entitled to a broad range of social security benefits, including pension schemes, maternity benefits, life and health insurance, and so on and so forth. The reforms did not change these. They continued the existing framework on social protection for formal workers. However, my argument is, since the state has substantially withdrawn from labor relations, in order for the state or the law to keep balance between individual liberty and social solidarity, the scope of social solidarity or social security should have been expanded, shouldn't have continued the same. And this expansion of social security is particularly stark with respect to unemployment insurance. So when COVID hit, the government found that the unemployment insurance that formal workers enjoy, it was not sufficient. And therefore, they had to come up with ad hoc social support for formal workers. And that's just an example to suggest that even when there is social security, I mean, there is everything, but the actual content of those are often not enough for supporting workers. So my argument in the book is that reforms increase workers' exposure to the market with no commensurate increase in social security. And then this is another argument that I pursue in the book, is relating substantive equality and social security to informal workers. The argument is what Parliament suggested is that they wanted to extend social security that are available for formal workers for informal workers. So replicate the social security for formal workers in the context of informal workers. But I've suggested that that doesn't quite meet the standards of substantive equality, because the market unfreedom for informal workers, that's the 90% of the workforce, is much more significant than that of formal workers. So if there needs to be a balance, the social protection mechanism ought to be much more extensive for informal workers as what exists for formal workers. The other thing I wanted to point out, that with respect to informal workers, the social security are problematic at two broad levels. So whereas formal workers have entitlement to substantive guarantees such as pension and unemployment insurance and so on, informal workers only have entitlement to a social security board. And then it'll be the boards that will get to decide what ought to be the social protection benefits for informal workers. That's at one level. And at the second level, it's problematic because these boards are occupied by government officials. So government occupies 2/3 and sometimes more of these boards, and then the rest of the worker and employer representatives are selected by the government to become part of the board. So constitutively, I think it's problematic, whereas I have suggested in the book that whereas the boards could have been the basis of a very robust deliberative process in articulating legal standards, they would fail to do so because it's so much controlled by the government. And finally, wanted to quickly mention that with respect to workers' participation, the reforms are deficient. Every trade union in the country opposed the passing of the laws. Every trade union, including the ruling government's trade union. They have objected to the reforms in the country. And when you look inside the law, workers' involvement in redistribution pertains to two things. One is collective bargaining, and second is participation in the creation of welfare standards. But both of these are quite constrained. For formal workers, while there is collective bargaining process, a recognized collective bargaining process, the right to strike is quite limited. And it continued to be limited, and as articulated by the Supreme Court, continued to be very, very narrow. And informal workers are excluded from such collective bargaining process, but they primarily negotiate with the government with their rights. So as I say, the Code of Social Security mandates the creation of social security boards to organize and distribute benefits. I think this could have been a good approach to decentralize social protection mechanism, but since the government has taken ownership of the Social Security Board, I doubt to what extent such deliberative framework would be the basis of such entitlements. I'll skip this one and I'll end with this. So what I've suggested in the book, especially in the conclusion chapter, that we need to move away from a contractual understanding of labor law to a social justice-oriented understanding of labor law. A justice-oriented labor law, the advantage is that it's not going to be deferential to the market logic or market exchange. And it is better capable of integrating lived experiences of these diverse categories of workers in the lawmaking process. I suggest that although the book is focused on India, and here I'm trying to make myself relevant for other jurisdictions as well, I think it's the argument could be used in other contexts as well. More recently, a colleague from Hong Kong University, Jedediah Krong, he was documenting legal history between the United States and Liberia. Liberia was a territory of the United States for a long time. And then he found a lot of Supreme Court cases wherein when Liberians are seen as not complete citizens of America, but they're seen as contributory citizens of America. And I've heard these things in other jurisdictions. Indian Constitution offered me an easy case because it's enumerated in the Constitution, but I think the same logic could be extended to other jurisdictions as well. And I do think this is an important project to pursue, especially in view of increasing migration to different regions of the world, increasing platform-based work, AI in work and enterprise, and concerns about sustainability. All of these could be better addressed if we adhere to a social justice approach to labor law. I'm going to end there and pass it over to Petra and Sean.
Thank you very much, Supriya, for that walk through the 2020 amendments to the labour law in India. I think the two of us have prepared a few brief reflections, so I might ask Professor Sean Cooney to go first.
Yeah, okay. Is this, yeah, all right. So, well, first of all, thanks, Supriya, for your presentation, which I super enjoyed. And I think it's a great book to interrogate the reforms from the perspective of the Constitution. And so I really like the whole kind of framing of it and the way that you've carried that through sort of analytically. I wanted to, well, first of all, I wanted to welcome you to go down the Great Ocean Road as you suggested, and it's better than Tofino, and that's a joke I'll tell you about later on. But anyway, but I thought I've got to make some few remarks just from my perspective, or my experience, one of which is working at the ILO. And while I was at the ILO, we were working with the Indian government on the reforms, and I spent some time in Delhi. And I just want to make, insofar as it's proper for me to do so, just some observations about that. And secondly, as someone that's done quite a lot of work in East Asia, just to sort of make a bit of comparison, other people have done this as well. So make sure I don't talk for too long. So on the first point about the process of drafting the codes, we just were, I remember being in Delhi like 4 times in 2015 when the codes were being drafted, especially the wages code and the health and safety one. What struck me, I suppose, I won't go into the specific negotiations, although there's probably some public things that can be said, is that the people that were working on it, and partly this is a function of the way I think South Asian bureaucracies work, like they keep transferring people around. So there wasn't, like, what struck me is kind of not a lot of interest in other countries, what other countries were doing. So it's like they took all those like hundreds of laws and just like threw them together, and in a fairly hurried way. And so I think the kind of deeper level analysis that you're doing, I'm not sure if that was conducted. Like, I suspect it wasn't. And I also think that, you know, perhaps there are a lot of innovations, progressive innovations in labour law that weren't really inconsistent with what the government wanted to do, that maybe weren't picked up at the time. So, for instance, you referred to work health and safety, and you know, it's a very traditional approach to work health and safety compared to, say, more here or Singapore, where it's very participative and kind of promotive of voice. So that's the first point. The second point I wanted to make is, well, the 2 related points. One is just to go back to the Indian Constitution, which I think it's a marvellous cultural artefact. It's sort of like, you know, sort of given to the world. It's a bit like the zero or something. You know, like it's just compared, looking at the perspective of a country which just doesn't have a constitution that has any lofty ideals in it, and whenever someone tries to put it in, it's unsuccessful. It's like really interesting and very, you know, obviously the Indian constitution has been very influential in many countries. So the challenge then, as you point out, is how to operationalise those ideals. And I really like the point you made, sort of in passing, about the judicial adjudication point, because a lot of people say, oh, wow, the Indian Supreme Court, they're so fantastic and they do all these, you know, make all these amazing judgments. But then the other side of that is the litigation and the lengthy dispute resolution, and this sort of focus on rights rather than practical regulatory measures. And I will do the inevitable bad thing, which do a bit of a contrast with China. And you know, obviously in terms of rights, it's very, you know, you can't constitutional rights in China are not justiciable. There's all these limitations, etc., etc. However, like, they have been able to reduce informality very extensively through these kind of practical measures like enforcement of written contracts, and they've also been able to address litigation by having quite efficient dispute resolution bodies, and questions like contract labour by putting quotas on. So that's not to say China is better by any stretch of the imagination, but there's kind of like an orientation towards practical outcomes. And I wondered if that ties in with your judicial adjudication point. So why I think that, you know, the Indian jurisprudence is just like a million miles ahead of the Supreme Court of the PRC. At a practical level, there's that differential outcome. I wondered if you wanted to comment on that. And then, this is controversial. So the last thing, well, it's all controversial really, but the last point I wanted to make is something I've noticed, because I was in Pakistan last year, I was in Sri Lanka, and one of the issues in South Asia that, as a real outsider, that I've picked up is there's this colonial legacy that sort of overlays and interacts with kind of traditions of eliteness and social status. And the impact that seems to have in labour law is that it's really hard. Well, it's very hard to talk to people about this kind of common worker as being a common status for everyone, like that we're all workers, and such pushback throughout South Asia when you try and say, well, a judge is a worker, or a manager is a worker, or a cleaner is a worker, and you've all got that in common. Like, it's really affronting. And I wondered if you, and that sort of again, kind of the vision you've put is one of equality, like where everyone participates. And I wondered if you want to comment on that. So there are my remarks.
Sure, and I might just add a few brief points as well, and then we'll allow Supriya to respond. So my reflections, I kind of frame them around 3 different issues. Firstly, the analytical framework used in the book. Secondly, the focus on informal workers. And thirdly, yet another self-indulgent comparison with another country, which I know best, which is Indonesia. So about the framework, I found it really interesting the way you set the book up. Use the Constitution as a source of values against which you then evaluate and measure the labour laws of India. And the labour law itself is presented in a very general level, and you call it an overall character. And for someone who likes a lot of political and social and legal detail, I found that a little disorienting to start with, but I came around to the idea of this broad comparison as I read the book. But I did wonder whether there was another possibility here, which was not comparing labour law with the constitutional values, but labour law with the international values that emanate from the ILO. Obviously, there's local differences, but I wondered whether you might comment perhaps on that analytical choice that you've made. Secondly, I really like the emphasis on informal workers and the law in the book. Often they're kind of relegated to a second thought or, in an analysis of labour law. So really great to see that. And I like the argument that you make that we need to conceive labour law more broadly as including social protection so that we do pick up where informal workers sit. That really resonates with the work I've done in thinking on informal regulation. And then the self-indulgent comparison with Indonesia was really just to note that, my goodness, there's a lot of parallels between the two. Indonesia in 2020 also passed a major reorganisation of its labour law, totally rejected by all labour unions. It was also framed by the World Bank's Doing Business Index, ironically, of course, given that the index was shortly afterwards abandoned.
Got a new one now.
Oh, there's a new one.
Yeah.
Oh, I better check that. It was a consolidation of law as well, bringing together different sources of labour law, and it just really struck me that there was a lot going on. The COVID context allowed a market-oriented government to push these through. Some differences. Indonesia was really about reducing individual worker protections. It didn't do very much in relation to collective rights, which was, I guess, a good thing. But yeah, it just really struck me that there's this parallel, and maybe picking out the similarities and differences might tell us a little bit about the directions that have been chosen in India and also Indonesia. So those were just a few thoughts. So maybe back to you to respond to either of those, and we've got time as well to then ask for any further questions.
Fantastic. Thank you very much. Thanks, Sean. Thanks, Petra. Great comments, and thanks for reading the book so kindly. I was expecting to be ambushed by both of you. You didn't do that.
Come back, we don't want to run away.
Thanks, Sean, for mentioning the constitutional adjudication and enforcement of judicial decisions and that distinction. I'm glad that you are with me on that, and that's been a long-term thing. You see constitutional lawyers, when you see them writing, they're just keeping on writing on what the judges said, and at some point it becomes so tiring, So I wonder when will I find a constitutional lawyer that is interested in politics? And I found legislation to be the site of politics, and I like that because normally what happens in law generally, especially in common law, and I've said this before, so law is a backward-looking discipline, right? Especially in common law. When we are stuck, we look back. What did Lord Denning say in 1962? Oh, goodness. We are going back to 1962. Businesses are forward-looking. They're looking for more and more profits, right? Now their latest muse is to send people out in space for leisure. So how do you engage with a scenario where law being very conservative and looking backwards, and businesses and our workers are involved in endeavors that are very forward-looking? So I think politics is the answer. So we have to have legal imagination that ties law with politics. And I think legislation offers us, to a great extent, that kind of an imagination. Although in post-colonial societies, I would normally say global south, but I'm mindful that I'm in Australia. So I'd say in post-colonial societies, the challenge often is that legislation is often incomplete, and there are other supplementary normative spaces that exist outside the formal institutional mechanism. So in that sense, I do feel that legislation is the way to evaluate social justice principles, and especially labor law is the site to engage at these with these things. So, and that ties well with the second component that you pointed out, comparison with China, very practical oriented, focused on resolving practical issues and so on. In some senses, that's good, but then when this happens at a totalitarian state, I'm not very confident how well these are giving people's autonomy or even solidarity and participatory democracy. So I am hesitant, especially with the Chinese example, but otherwise I would think in my own imagination for a democratic polity, like broadly democratic polity with Narendra Modi, we don't know yet how things are going, but in broad democratic polity, my own understanding of labor law would be, there is an overarching idea, a constitutional imagination, and there are legislation, but within those legislation, I imagine enough scope that gives space for decentralized lawmaking. So what you have referred to as practical problem solving at a decentralized level, but I think for me, it works well in a broadly democratic jurisdiction. To what extent it works in China and what extent we should emulate that, I'm doubtful. Yeah, so I am not very hopeful that at the, say, not at the Politburo level, but in the local committee of the Chinese Communist Party in the different jurisdictions, to what extent you could ignore them and engage in some of these practical resolution, I'm not so sure. And I like, Sean, your point on everyone being worker, from judges to domestic workers, and you're totally right. For example, India is colonized in such a manner, and you don't see only in cricket, but also you see it in the way people behave. India is, so Ashish Nandi, the political scientist and anthropologist, pointed this out. First they come for your land, and then they come for your head. So they came for your mind, right? So and that has been, to a great extent, colonized, and in the conclusion chapter, I kind of take on the judges a little bit, saying that, well, you don't have to look at US and UK judges and cite them. I mean, it's not a pedantic exercise. It's just because when judges cite from US and UK, I think they find it as part of their status, that we are in the same system and so on. So I've argued that that's probably not necessary. So that's what I've argued. And I think the idea of worker citizenship allows us to see these range of people, everyone as contributory citizen. I think that's an idea that one could pursue much more vigorously, I would think. And thanks, Petra, for the great comments. Yes, I thought informality will have to take it simultaneously, even though it has been left out of the general jurisprudence of labor law. But in the Indian context, we can't talk about labor law without taking informality seriously, because 90% of the population work, 90% of the workforce work in those fuzzy relationships, So comparing labor law with international values as opposed to constitutional values, at a political level, I think there is a good reason to adhere or to think about constitutional values, because apparently it emerges from within the jurisdiction rather than international values, wherein the ILO's Director Generals have mostly been from France and then UK and all of those things. So it's a very, it's a continuation of the colonial system. So I think there is a merit to focus on constitution, but I do see that it might be a useful endeavor to compare labor laws with international values, to what extent they're met, and so on. And Sean, you've worked with ILO, so you'd know that India is, well, they don't often ratify ILO commitments and so on. So I don't think India had ratified 2 or 3 of the 8 fundamental ones, but it's been imposed in any case. Comparison with Indonesia, I am up for it. If you wanted to do it, it'll be great. Yes. So I'll stop there. Thanks both.
Okay, well, I think that might be time to wrap up the discussion this afternoon. Thank you so much, Supriya, for coming and sharing your messy picture of labour law and social justice within the framework of India. Really appreciate you coming to Melbourne and speaking to us. So thank you very much.
Come back and stay
visit.
longer.
Yes.
I will do that.